Good afternoon, everybody. My name is Stephen Pike, and I'd like to welcome you to our webinar on Canadian ESG for in-house counsel. We're delighted that you could join us today. We have a terrific program for you and an amazing panel that I'm going to introduce right away. We have Jennifer King, who's an environmental lawyer and partner in Gowling Toronto office. She practices environmental law in Ontario federally and in Nunavut. She provides strategic regulatory advice on a wide range of matters, including environmental impact assessments, natural resource development, and major infrastructure projects, including those in Canada's near and far north. She represented an intervener, the Canadian Public Health Association, in the recent reference before the Supreme Court of Canada regarding the Federal Greenhouse Gas Pollution Pricing Act. Jennifer's a climate governance expert with the Canada Climate Law Initiative. Welcome, Jennifer. Linda Hogue is a partner in our Vancouver office and practices in the area of corporate and securities law. She provides advice on all aspects of regulatory requirements for public companies, including corporate finance, M&A, proxy battles, and has taught business law at the BC Institute of Technology and UBC. She's spoken on ESG and the role of the board to the members of Women Get On Board and on building a sustainable mining sector at the PDAC 2021 conference. Welcome, Linda. Nita Gupta is a partner in our Waterloo office. She deals with human capital management in her employment and human rights practice. She's also co-chair of our firm's Diversity and Inclusion Council. Since the beginning of the pandemic, Nita's been working on difficult issues and advising employers on COVID-19 in the workplace, health and safety, work from home, return to work, vaccination, mandatory vaccination policies, and vaccination incentives. Welcome, Nina. I'll be the moderator this afternoon. I'm Stephen Pike. I'm a business law lawyer based in Gowling's Toronto office and work in ESG on supply chain and human rights issues, as well as corporate governance aspects of ESG. Our format today will be an active panel discussion, not a lecture. We're going to have a Q&A format. And because ESG impacts all areas of Canadian businesses, I'm going to ask the panel a wide variety of questions, everything from environmental to diversity issues, from Indigenous peoples to M&A, and from human capital management to due diligence. In addressing and advising on ESG risks and opportunities, it's critical for in-house counsel to do so within a well-informed context and with acuity. In my view, ESG factors are not generic. They're not identical for every business or for every industry or even for every region or country. So to help provide context for in-house counsel in Canada, we want to provide you with some insight into Canadian ESG factors and issues. And you say, well, what are these Canadian ESG factors and issues? Well, they're unique to Canada, and let me give you some examples. You'll hear more in a couple minutes. Indigenous peoples in Canada are stakeholders, but they're stakeholders with constitutionally protected rights and interests. That's unique to Canada. Canada is an Arctic nation. As we'll hear from Jennifer King, there are social justice, and environmental issues in Canada's Arctic that are unique to Canada. Human capital management in Canada is unique. Canadian workplace laws are very different than those that we see in the US. And speaking of the US and ESG, we have different environmental laws and regulations and project approval processes. From a social perspective, we have many similar social and social justice issues, but we have many that are unique to Canada, such as French language rights in Quebec and outside. And from a corporate governance perspective, we're very different than the US. We're shareholder primacy, the premise that businesses exist and are run for the benefit primarily of shareholders, is the law. In Canada, the interests of stakeholders have been recognized as a legitimate part of the board's considerations when it's fulfilling its fiduciary duty to act in the best interest of the corporation. According to the Supreme Court of Canada, stakeholders can include shareholders, employees, suppliers, consumers, governments, creditors, and the environment. And with the codification of the BCE case in the 2019 amendments to the Canada Business Corporations Act, pensioners and retirees and the long-term interests of the corporation were added to the list of interests that boards of directors in Canada can consider. So it's in this context that our discussion of Canadian ESG can begin. The first question that I want to put to the panel, and I'll put this question to Jennifer, is why have climate change and climate risk factors become an immediate critical issue for Canadian in-house counsel?
Thank you, Stephen, and thank you for that introduction. I'm going to talk about 4 reasons why climate change risk factors have become an unavoidable and critical issue for Canadian companies and their legal advisors. First, climate change is already physically impacting Canada. Second, its impact is disproportionate on our most vulnerable, including Indigenous communities in the North. Third, regulation of greenhouse gas emissions is quickly evolving and proliferating in Canada. And finally, COVID-19 has shone a spotlight on climate change in Canada and across the world. So turning to the first factor, climate change is already impacting Canada. It's no longer a future risk. Chief Justice Wagner, in the recent decision regarding the Greenhouse Gas Pollution Pricing Act, which was just released last month, said that it's the essential factual backdrop to the appeals is uncontested. Climate change is real. It is caused by greenhouse gas emissions resulting from human activities, and it poses a grave threat to humanity's future. The only way to address the threat of climate change is to reduce greenhouse gas emissions. So the urgency and the public interest in mitigating the impacts of climate change is understood. And the Paris Agreement target to limit global warming to 1.5 degrees Celsius will require a shift with rapid and far-reaching transitions in land, energy, industry, buildings, transports, and cities. In other words, the shift will affect Canadian business in every sector. Climate change is also different from other ESG risks. It's understood to be a systemic and interconnected risk that can act as a risk multiplier. And that's what the World Economic Forum recognized in its recent report on global risks. Climate action failure is linked to water crises, food crises, and infectious diseases. And as we saw last year with the wildfires in Western United States, which had direct impact on the health of Canadians across the border, it's a borderless issue. Second, I'm going to speak a little bit about the disproportionate impact on Canada's north. So in 2019, the federal government released a scientific report noting that Canada is warming at twice the rate as the rest of the world. And in the north, it's 3 times as fast. This was also recognized in the recent Supreme Court decision, where the majority found that the effects of climate change have been and will be particularly severe and devastating in Canada, and particularly in the north. Evidence of warming can be seen in the thawing of permafrost. So permafrost is land that is permanently frozen except for the top layer, which freezes in the winter and thaws in the summer. And when it melts, permafrost exposes carbon dioxide and methane, which contributes to warming. And it also has other impacts on the landscape in the north, which is related to projects in the north and mining operations in the north. What they're finding is that oil and gas industry waste pits that were supposed to be frozen in the permafrost forever, that were built in the 70s and 80s, they're thawing, and the waste is now migrating into freshwater systems. An example of this is Giant Mine in Yellowknife, which was built within the municipality of Yellowknife, and the gold mining there created waste, arsenic trioxide. And when the mine went bankrupt, the government was left with the task to store the waste, and the government at the time decided to keep it underground, frozen in the permafrost. Now the permafrost is melting, and we're going to have to come up with another method for maintaining it. And perhaps for years, we'll all be paying to refrigerate it. So we're seeing the Nunavut Impact Review Board, which is Nunavut's impact assessment agency, is not talking about climate change and talking about the immediate impacts in the Arctic. And we're seeing proponents change the design of their projects, dealing with different contingencies, and really dealing with impacts on waste management right now and having to adjust plans and project designs from only a few decades ago. There's also a lot of third was about changing regulations, and that we have the Canadian Impact Assessment Act, which replaced the old Impact Assessment Act in 2019, and it's put climate change front and center. A project will only be approved if it's in the public interest, and public interest includes consideration of the extent to which the effects of the project will contribute or help Canada's ability to meet its obligations with respect to climate change. There's a lot of regulation across Canada now that's proliferating about climate change. And with the Greenhouse Gas Pollution Pricing Act reference decision that just came down, it's the Supreme Court has made it clear that not only one level of government can regulate climate change or greenhouse gas emissions, all levels. And so what, as in-house counsel, you'll see is that there's changing regulations across Canada with respect to climate change. You're going to find regulation at every level of government, and there's kind of a patchwork map right now with respect to even just carbon pricing, which is only one method to combat climate change. Back to you, Stephen.
Thank you very much, Jennifer. Nina, I've got a question for you, but first I want to just mention to everyone who's enjoying the presentation and our discussion, that if you have questions, we're going to try and have a Q&A session for your questions at the end of the webinar. Feel free to pose them using the Q&A function, and include your name in case we're not able to get to you when we do the Q&A session, so that we can follow up with you after. Okay, Nina, what ESG trends in the workplace are you seeing that are unique to Canada?
That's a great question, Stephen. And I want to start by picking up something that Jennifer just said, and it was alluded to in your opening remarks, which is the importance of Indigenous rights in Canada. The world was galvanized last year and continues to be grappling with issues arising from George Floyd's murder, the conviction of Derek Chauvin, and the Black Lives Matter movement. In Canada, what we saw is those influences also included the calls for Indigenous justice and the calls of inclusion of people of color. And corporate Canada is not immune from those social pressures. There is increasing pressure on corporate Canada to be part of the solution, develop internal policies to retain, recruit, promote, sponsor BIPOC talent, and more importantly, to be seen as being vocally on the right side of history. So that's sort of, I would say, something that has really come to the fore in 2020, 2021. But I think there's actually a deeper and really inherent sort of difference. And it's the recognition of the judicial, regulatory, and maybe even the zeitgeist in Canada of the centrality of work. And one of my favorite quotes, and any employment lawyer on the call will recognize this quote, it's from Justice Brian Dixon, the former Chief Justice. And he said in the Alberta reference, work is one of the most fundamental aspects in a person's life, providing the individual with a means of financial support, and as importantly, a contributory role in society. And then he goes on to say, a person's employment is an essential component of his or her sense of identity, self-worth, and emotional well-being. Accordingly, the conditions in which a person works are highly significant in shaping the whole compendium of psychological, emotional, and physical elements of a person's dignity and self-respect. And what we see is that permeates judicial culture in Canada. And it really, quite frankly, creates high expectations of corporate counsel and those advising corporations about the high standard employers have when they are dealing with their employees. And we see this, like, it's just consistent. So broad human rights protections for things like disability and illness, but also for elder care and child care, family care responsibilities. In the last decade, Stephen, we have seen increasingly higher standards with respect to psychological safety. I think Quebec led the way with their standards against psychological harassment, but all of the occupational health and safety acts contain broad protection against generic harassment and bullying. And conduct, quite frankly, Stephen, that when I joined the workforce in the last millennium was, you know, boys will be boys, it's horseplay, it's a blue collar workforce, it's a rough and dirty workforce, you have to put up with it, are no longer tolerated. In Ontario, we see the obligation to be very proactive about including people with disabilities and illness in the workplace. And that's really codified in a piece of legislation known as the Accessibility for Ontarians with Disabilities Act. We call it AODA for short. And there's a filing deadline coming up on June 30th. So shout out, we're doing a seminar on May 6th. For those of you who are a bit curious about what the filing deadline entails and what your responsibilities in Ontario are under that piece of legislation. In the courts, we see aggressive wage and hour class actions, huge fines for workplace injuries and fatalities, and huge damage awards for human rights violations. Maybe not huge by American standards, but certainly huge by Canadian standards. And you know, a decade ago, an award for $20,000 to $40,000 would be considered to be anomalous for a human rights violation. We're now seeing awards 100,000, $250,000, 900,000 for egregious violations, but nonetheless, the tribunals are enforcing human rights with a big stick. So bottom line, Stephen, I think for our listeners, many of whom are in-house counsel, they will have to pay increasing attention to how their workers and employees are dealt with in the workplace. There's clearly high, and I would say increasing expectations in Canadian corporations not to treat employees as kind of fungible pieces of the machinery, but also be very mindful of their personal circumstances. So high standards indeed.
Well, thanks, Nina. It reminds me of statements at the beginning of the pandemic about we're all in this together, and our first priority is the health and safety of our employees, that courts in Canada would be examining those carefully and making sure that, in fact, that the actions match the statements that were made.
Absolutely, Stephen.
Linda, in your work with in-house counsel, would you say that Canadian ESG factors are becoming more impactful on in-house counsel in M&A, corporate reporting, commercial agreements?
Thank you, Stephen. And absolutely. ESG is now a mainstream focus. It's assessed with the same rigor and the same traditional measures as credit and liquidity risk. You have to assess the ESG risk, and it's not straightforward. There are no unified metrics. The assessing of it can be difficult and different, as we all know, for different industries. You have to assess the key and setting the materiality for your particular company. We start in any M&A in trying to establish value, and we start with a due diligence. And you have to assess due diligence from an ESG perspective. You have to, when beginning the process, look and ask yourself in the due diligence questions, a broader scope. Does the target have an ESG strategy? Has the target adopted an ESG framework? What is the target's approach to ESG governance? How has the target board been involved in understanding, developing, and implementing an ESG strategy, including the accountability for it? Are there management incentives in place to promote ESG? What ESG factors are relevant to the target's ability to operate its business? How do ESG factors influence key stakeholders to this business and their decisions? How does the target engage those stakeholders? And what is the history of stakeholder engagement? Are there sufficient personnel and other resources to properly handle ESG matters, and how are they deployed? So you see that your entire due diligence questionnaire must include and focus on these issues. Once you get through the due diligence and assess, you come to drafting the contracts as in-house counsel. You have to address the representations and warranties. Did that due diligence bring to mind things that need to be addressed specifically as opposed to just the general representations and warranties that you would have for that business? Do you need specific ESG contractual terms? Will there be a review of insurance clauses as to what the risks might be representing that due diligence? What about post-ESG integration of your businesses, and how can they be set up? You know, we talk about the ESG clauses which must be added, because if your due diligence identified a material ESG risk, you may want to consider a specific clause addressing that risk, because it will affect the value of what you're acquiring. Think of the target's compliance with applicable ESG policies and including that as a representation and warranty. Consider whether misconduct that implicates material ESG concerns, including possible allegations of sexual harassment or misconduct, or complaints on discrimination, and should that be included? We refer to these sometimes as the Harvey Weinstein clauses, and make people think that how would Miramax, his company, be judged and valued both before and after the issues with respect to him became to light? Are there any other social, labor, health, safety, security, environmental considerations, accidents? All of these things should be considered in the course of drafting the contract. So as counsel, once you've gotten through due diligence, representations, warranties, you've got to look at force majeure clauses. I mentioned that I agonized a force majeure clause on a very large transaction in January of 2020. And it had included the word pandemic as part of my force majeure, which was pushed back on very hard by the other side, but it stayed in, and thankfully so. That was a transaction that we needed that clause as we worked through 2020 to closing. And what happened through that clause, as I saw that, which was signed up in February and closed in August of 2020, it changed values as to how we looked at ESG through that process. That particular transaction was a large mining acquisition in South America. And you had to talk about the human capital. How was the mining camp designed? I mean, and the value of that had to change. That changed our structure of what our value was, because usually those were communal. That had to change in COVID. How was quarantine managed? Usually people in remote areas worked 2 weeks on and 2 weeks off. That had to change when you added a quarantine provision to that. And how did that affect your employees and how they were able to function? And we did find retaining was harder. People didn't want to be away from home for a month, and quite legitimately so. Sadly, in that process, there was a COVID outbreak at that particular mine site. We had to address it. We did not have a COVID policy in place, and we will not face that again. We will ensure, as in-house, there must be a COVID policy in place. It must be a standard part. We had to regain the social license to operate, both locally, regionally, and nationally with that government, and worked through that successfully. But had to reestablish that social license to operate. So as in-house counsel, you have a whole process in any M&A transaction of how to value it and how will ESG affect that value. What are your due diligence considerations? What clauses do you need? And how will you address those throughout? Back to you, Stephen.
Thank you very much, Linda. Nina, back to you. Linda provided a great segue in terms of COVID-19. How has COVID-19 impacted human capital management in Canada?
I think, Stephen, in every way, and in ways I think no lawyer or in-house counsel anticipated at the beginning. And I joke that, you know, I have job security because, like, the incoming is unbelievable. I'm sure it is unbelievable for our audience as well. So let's start thinking about what COVID-19 has proven for us. A lot of us have had to work from home. This panel discussion is although we have lovely backgrounds, is really from our bedrooms and spare rooms and offices and basements across the country. And work from home or work from away really presents complex legal and HR challenges with respect to maintaining confidentiality and security of data. You know, something as simple as what are you going to be allowed to print? How are you going to shred paper? It's also raised difficult questions about that work-life balance, which I personally don't think exists, but let's just leave that aside. How do you maintain traditional timekeeping systems for somebody who might be working from home and having to take time off periodically, intermittently during the day to take care of young children who are homeschooling or need lunch or need a nap, don't have daycare, don't have childcare because nobody can come into your home? And then how do you deal with maintaining hours? And so we're now seeing, you know, wage and hour litigation arising from the work from home phenomenon. We also see a huge amount of vacation time that isn't being used because I don't know about you, but I don't want to take a vacation where the only place I'm going to go is, quite frankly, my Zoom screen. And so how are you going to deal with that backlog? We've seen challenges to layoffs, wage reductions, job sharing. And in fact, the cases that have come out, Stephen, to my surprise a little bit, have essentially said that the law of constructive dismissal, as we knew it pre-pandemic, still applies. And so if your company did a wage rollback, a layoff, or in Ontario, we call the infectious disease emergency leave, job sharing, you could still be facing a huge constructive dismissal piece of litigation. And quite frankly, honestly, I anticipate a number of class actions because of that. Companies are now grappling with, Stephen, really intriguing questions. Should we pay people more if they physically come to the office? Should we actually pay them you know, less if they come into the office because they're costing the company overhead? And there's no right or wrong answer. It's just a question that in-house counsel are now grappling with. I also think in-house counsel have become embedded in health and safety. So you heard Linda talk about, you know, the lack of a health and safety plan. How do you deal with physical spacing in a mine? Well, those questions are being replicated in every workplace. We have people who genuinely don't want to come back to work physically in the workplace. Sometimes because they're legitimately afraid of catching COVID, they have an autoimmune disorder, they live with vulnerable people. And then some people are discovering the joys of software programming from Costa Rica or perhaps back home in Vietnam, China, or India. And I just shout out those countries, not because they're exclusive, but they're the ones that I dealt with in the last 2 weeks. And when work from anywhere becomes something more than a short vacation, there are really complicated international tax benefit, whether or not you are establishing a presence in a foreign jurisdiction by virtue of an agency relationship with a senior employee or officer, and of course, labor compliance issues, conflicts of law issues, whose rules apply. And so as we return back to the office, and Stephen, I'm desperate to get back to the office. I am sick and tired of my dining room. I see in-house counsel having to grapple with things like PPE, health and safety, the HVAC system and whether they meet safety standards, whether the cubicles are in fact 6 feet apart or 10 feet apart, things that quite frankly, law school never prepared any of us for. And more importantly, I think in-house counsel are going to have to grapple with the huge impact of the George Floyd and Derek Chauvin interaction, and how are we going to grapple with diversity, equity, and inclusion and make sure our companies and clients are on the right side of those issues. So I think in-house counsel are just going to be busier than they have ever been before, Stephen.
Well, thanks, Nina. I think we'll hear from Jennifer on the climate change side. It may be the same. The climate change litigation that we've heard about in the news, Jennifer's been focused on really state and government decision makers. Are companies now facing litigation relating to climate change issues?
Yes, Stephen, they are. I think I would commend everyone who's more interested in this to look at the UN Environment Program Global Climate Litigation Report. They just published their report regarding 2020 status in January of this year. And what the report has found is a rapid increase in climate litigation around the world. And to give you just some stats to ground that, in 2017, there were 884 cases brought in 24 countries. As of July 1st, 2020, those cases had nearly doubled, with 1,550 climate change cases filed in 38 countries. And the reason why this is important for in-house counsel and Canadian companies is that Canadian litigants are heavily influenced by US and international cases, and we'll talk a little bit about it. This litigation is compelling governments and corporate actors to pursue more ambitious climate change mitigation and adaptation goals. And the other, we're seeing the scientific understanding of climate change and causation of climate change, that's also improving, which is also leading to more litigation risk as science is better able to establish causation. So the UN report categorizes climate change litigation in a number of categories, and I really want to talk about three: litigation against governments, litigation against governments that impacts directly private projects, and litigation that targets private entities. And what you'll see that's common between all of these pieces of litigation is that there's a real emphasis on the public interest. There's often multiple parties, and often what we're seeing in Canada is multiple interveners. So in the past, litigation with respect to climate change has really focused on governments, climate rights. What we're starting to see is that some of this litigation is gaining some traction, particularly from the perspective of youth. So in Canada, a class action was filed in Quebec on behalf of citizens aged 35 and under. This class action was dismissed by the Superior Court of Quebec in 2019, but the Quebec Court of Appeal just heard the appeal in February and the judgment's pending. In Ontario, there's the Mather case, M-A-T-H-U-R, where youth seeking a declaration that the new target set by the province of Ontario to reduce greenhouse gas emissions was not sufficiently ambitious and violated their rights under the Charter, Section 7. So they submit that they have a constitutional right to a stable climate system. That case survived a motion to dismiss and is ongoing. These Canadian cases are modeled on international and US litigation. There was a case in the District of Oregon brought by 21 youth plaintiffs that was dismissed, but that was a few years ago, and you can kind of see these cases learning. And there was another case, the Urgenda case, which is quite famous in climate change litigation, where the Supreme Court of the Netherlands in 2019 found that the state owes a duty of care to protect its citizens from climate change. The other type of litigation I want to talk about that we're familiar with are when companies are caught up in litigation against government actors. So the Greenhouse Gas Pollution Pricing Act case, which I've already talked about briefly, the federal government passed a law a few years ago that essentially sets a backstop for carbon pricing in Canada and tells everyone across Canada, all the different jurisdictions, that if you don't have carbon pricing that meets the federal government standards, then the Canadian law applies. And a number of provinces challenged that. And as a result, it was challenged all the way up to the Supreme Court, and the Supreme Court upheld it. And now we can see climate or carbon pricing regulation across Canada changing. And of course, that affects companies, and that affects the advice that in-house counsel will be giving to the companies. The other type is with respect to impact assessment. So if a project needs a permit, and I'll give an example from Australia. So in Australia, Gloucester Resources proposed a new coal mine. The Minister of Planning, they rejected the mine due to just typical land use planning concerns. The company appealed that to a court in Wales. And the process is very similar to Canada, where the proposal was evaluated on the basis of planning concerns and environmental and social factors. But the Chief Justice in that case went a step further and said that if Australia is going to meet its Paris Accord commitments, they can't be approving new coal projects due to their downstream effects. And he concluded that the mine was in the wrong place at the wrong time, and really rejected that project on the basis of its GHG emissions. And we're seeing those kinds of cases here, those same kinds of arguments here. And now we're seeing a new wave of litigation against private entities. The first wave of these cases were not successful in the States, largely in the States, tort claims and public nuisance claims, because of the causation problem. How can you say whether or not one company's emissions are really causing the impacts of climate change? But there's a real new emphasis, a second wave of these kinds of challenges. And for example, and we see them as class actions. I know Nina was talking about class actions. I'm going to tell you about a case that didn't actually proceed, but you can see how this is kind of giving us a, we're looking into the future on what we might see. So in 2019, the municipality of Victoria became the first municipality in Canada to endorse a class action lawsuit against oil and gas producers for climate-related harms. The Victoria City Council resolved to support the class action, and this got a lot of press out west. I don't know if Linda heard about it at the time, but this was to enable Victoria to safeguard the financial interests of its residents by recovering costs for climate-related harms, really a focus on infrastructure. Now, this lawsuit did not proceed for a number of reasons, but it was modeled after a US case where the city of New York brought a case against ExxonMobil Corporation. Very similar arguments, and it's really, it was a lawsuit against Exxon for misleading shareholders over the true cost of climate change. And in that case, the court ruled in favor of Exxon in December 2019, but the facts matter. And like I've said, the science is evolving, and we're getting more and more scientific technical information about causation. So we'll see what happens in the future. We're also seeing cases around climate disclosures and greenwashing as there's more of a public focus and a demand for green products. There's also consumer challenges against greenwashing. So for in-house counsel, when you're thinking about litigation risk, we need to look abroad, look to the South, look internationally with respect to climate litigation, how it's evolving. The Supreme Court in the recent decision from last month relied on the two of the cases that I just mentioned to you, these international cases. So with climate change, legal precedent isn't just about Canadian precedent, it's global. Back to you, Stephen. I could speak about this a lot longer. It's very interesting to see the litigation evolve and just really looking internationally to see where it's going.
Well, thank you very much, Jennifer, for a peek around the corner as to what's coming in Canada, and part of which is already here. Linda, from your perspective, how are in-house counsel involved, and how in managing and budgeting the costs of dealing with ESG factors in the corporation and the reporting of ESG issues?
The in-house counsel have a very large role in this. Companies now have to have, and depending upon your size, whether it's an ESG officer or an ESG committee, these are fundamental frameworks that a corporation must have. And you say, why should in-house counsel take this on? Well, they're the obvious place where this repository exists. As in-house counsel, you enjoy a broad visibility and engagement across all organizations' business lines. You're intimately involved in the development of corporate policy and standards, as well as in compliance, governance, human rights, anti-corruption, diversity and inclusion, enterprise risk management, all of which are at the heart of ESG. You are sometimes referred to as in-house counsel as the conscience of the corporation. You align yourself well with ESG. You are a strategic and trusted business advisor with a direct line to corporate leadership, which is the critical, effective development, implementation, and oversight of the framework of ESG. So you are at the center of this, and you must establish and develop an ESG policy. You must see that it meets, that it has metrics, that it is working from. I may have made the comment with Nina before that we have now in a workforce 5 generations working in a workforce at the same time for the first time in history, all motivated by different things, all with different goals, all with different expectations that have to be met. You have to develop, and this becomes critical in your reporting, An ESG repository. This is a critical piece of your framework. It records your organization and what they're already doing in terms of ESG categories. This repository performs really two functions. First, it serves as the central database to measure and track your progress across the various priorities. Second, it provides a useful resource to inform the ESG story as you have to convey it both internally and externally to your various audiences. And you must develop an external facing communications plan. You have to draft public disclosures in public companies and how you're going to address those. There was a key market put out by KPMG that noted that 92% of Canadian companies are now reporting on sustainability. 74% contain Canadian companies include sustainability in their annual reports. 62% of companies are disclosing carbon reduction targets. 62% acknowledge the risks of climate change in their reporting. All of these things have become critical. Now, as Jennifer speaks to all of the litigation we've seen and the litigation that will likely come, as in-house counsel, your role is to try to ensure that your company has met the metrics without facing litigation. You're at the forefront of defining the role that sees your company is not in litigation. I use as an example of that over 20 years ago, I was approached by EcoJustice, who were then called the Sierra Legal Defense Fund. And they came to me and said, we are litigating all of these decisions after the fact, and it's years and time consuming and expensive. And yes, it's our role to make this happen. But we think we can be more effective if we're in the boardroom, if we're there when you're making the decisions, and know that those decisions are including environmental, social, governance issues. And we might save ourselves years of issues after the fact. And we did that. I served on their board for years, and I brought their mindset into the mining company boardroom, and the mining company boardroom back to their mindset. So there was a communication which created better decision making. And I think as in-house counsel, that's a place you can play a role.
Thank you very much, Linda. That's really good insights into trying to solve problems early. Jennifer, talking about problems, and you've identified a number of business risks, but in-house counsel should also be considering the benefits and opportunities of dealing with these issues. As Linda has alluded to, can you talk about climate-related opportunities available to Canadian companies?
Yes, I can. And I certainly can't cover the field of opportunities in a few minutes, because on the other side of risks, you always find, of course, opportunities if you look carefully. And with respect to COVID-19, I will say that some of the recovery plans are being linked to a green recovery. So access to COVID recovery stimulus in Canada, for example, the large employer emergency financing facility, which was announced last year, requires that the bridge financing requires a condition that you must publish annual climate-related disclosure reports as part of access to that stimulus. So there's an opportunity that is tied to a requirement to disclose. The pandemic is confirming what environmental experts have been saying for years, which is that companies with good governance practices, including ESG and environment, are better positioned to manage risk. And what we're talking about today, we see that ESG funds are outperforming the wider market. So there's opportunities also for companies to access new markets with new technological innovations. Think battery storage, artificial intelligence, or smart metering. There's also new low emissions products and services that can improve competitive position and capitalize on the shifting consumer and investor preferences that we've been talking about today. But really, I do want to take a minute to speak about, to come back to the Indigenous perspective that we've been talking about today. That I think that what we're seeing now, and with climate change and with COVID-19 and the kinds of ESG risks, is that we also need to stop thinking about our Indigenous peoples in Canada as just a barrier or a risk. Consultation with First Nations has been, the Supreme Court of Canada in the recent years and cases have made it very clear that that the Crown must consult with First Nations. But I think we're seeing that we need to take it further now. And it's a good idea for project proponents to get ahead of the game by engaging with and consulting with these First Nations that may be impacted by a project. And then further, with the focus on ESG, there's now stimulus and laws that require First Nations participation in projects, not just consultation, but actual participation in projects. And it's evolving to First Nations and Indigenous peoples taking part in infrastructure projects, both on and off their lands. And I also think that as we come out of COVID, there's a number of infrastructure needs in our First Nations communities in Canada. And there's a recognition that there's mutually beneficial opportunities for large projects, infrastructure projects for both First Nations and industry. So I think this is something that, that we're thinking about as we recover from COVID-19. And I will say, just tying into what Nina's talking about, as part of all of this, there's also a push for Indigenous service providers for these projects, not just Indigenous involvement, but also consultants and lawyers. There's a push to have Indigenous consultants and lawyers and making sure that we're building that capacity, both in the South and in the North.
Thank you very much, Jennifer. Nina, from your perspective, again, looking around the corner, what do you see for in-house counsel in terms of preparing for human capital management issues in 2022 and beyond?
Oh, I don't think the world or the workplace will ever be the same again. And it used to be you go to work. Work was a place. Now work is really something you do. And where and how you do it is up for negotiation. So from an in-house counsel perspective, I see them going to have to see them having to work much closer with HR, tax, insurance, and benefits providers with respect to policies around that work from home, work from anywhere. How is compensation going to be run? How is that consistent with pay equity or human rights obligations? How do we have a flex time policy and still be competitive? We're also going to have to work with our IT providers with respect to online digital security, as well as dealing with some of the online bullying and harassment that we see. I also think COVID-19 reminded us that we have to take care of frontline workers. You know, it's really interesting. My son, who works at a pet food store, is essential. I am not, or at least not to the same degree of, certainly not from a perspective of risk. And how are we going to take care of the people who are frontline? And that's going to actually require us to plan and procure PPE and have strong policies and communications so that we can protect these people when somebody comes in. And every day my son comes in and talks about somebody who deliberately tries to cough in his face or, you know, not wear a mask or abuse him because he's trying to enforce the rules. And how are we going to protect those people? Health and safety, as I've alluded to earlier, is going to be a huge portfolio. And quite frankly, if there's one piece of advice I can give is hire more people in that health and safety area. Finally, Stephen, I want to talk about something I think Linda mentioned about the in-house counsel being in a real interesting role, the conscience of the corporation. I think corporations are going to be looked to really develop policies, not just about recruitment and retention, but things like supplier diversity and procurement plans. And then one thing we haven't talked about, we could probably spend the entire seminar talking about it, is the impact of workplace mental health. So our workers are stressed, they're tired, they're exhausted. But quite frankly, our lawyers and in-house counsel are stressed and tired and exhausted. And I was shocked to look at some research about just how bad lawyer depression, exhaustion, and mental health is. We have to be number one. We're 3.6 times higher than the general population, Stephen, in terms of depression. And suicide is the third leading cause of death for lawyers. And so if I were to end off in anything, you know, it's very easy to say, oh, you should be doing this and you should be doing that. But if we're going to be the conscience of a corporation, if we as a profession are going to try to take care of our clients and our in-house, our in-house clients, we have to really take care of ourselves first. So before you go and do all the to-dos that we've suggested on this call, Stephen, I really recommend that we try to take care of ourselves. And that goes for our in-house partners as well as the lawyers that are working in law firms. Without that, we're not going to be able to take on the challenges of the next decade.
Oh, thank you, Nina. Very, very wise. And I hope everybody who's on the webinar now will take that to heart. Linda, a quick question for you. How are you finding banks, private equity and investors, asset managers, shareholders? How are they assessing ESG and making investment decisions that are impacting access to capital?
This has become critical for companies at this stage. And as in-house counsel, you will have to, whenever you approach a bank, a private equity, or shareholder raise, you will be given an ESG score. And that score will be literally taken, assessing your regulatory risk, your litigation risk, your reputational risk, the environmental risk, whether there's been shareholder activism and what risk comes from that. We've seen in the last number of years, the most prominent things brought forward by shareholders are climate change, human rights, and labor standards. They're all critical points that are going to affect whether you are able to finance. You have to also look at ethnic gender diversity in your company and how that's addressed. Those are critical parts of the different pieces of it. There was a report done moving towards gender balance in private equity and venture capital in 2019, done by a division of the World Bank, that evidenced that the report revealed that private equity and venture capital funds with gender balanced general partners generated up to 20% higher returns compared with those that were majority male or majority female. We've all come to the understanding that diversity of opinion and diversity of view creates better decision making, and you will be judged on those things. That critical part of reputational risk comes forward too in these companies. There was an article published where the Norway government pension fund divested itself of all of its holdings in Barrick Gold, a well-known Canadian company, and quoted in their reason to divest themselves that Barrick posed an unacceptable risk of the fund contributing to serious environmental damage. And they went one step further and said that Barrick's assertions that its operations do not cause long-term and irreversible environmental damage carry little credibility. This is reinforced by Barrick's lack of openness and transparency in the company's environmental reporting. And this is where your ESG committee, in preparing and having that repository of information, is going to be able to increase your ability to access capital. There's definitely been a reallocation of capital toward investment strategies that place sustainability at the center of those investment decisions. There was a report published actually in 2020 by Ernst & Young that asked and stated when they looked at it that 74% of financial leaders are now saying that investors increasingly use non-financial information in their investment decision-making. So this is going to make an extreme difference in how in-house counsel prepare their reports. They actually stated that the ESG reporting finance showed was responsible for and deeply involved in creating more open and accountable reporting to win stakeholder trust. No longer will you be measured solely on financial metrics, such as earnings per share, dividend yield, and return on capital that benefits the investors. But rather, you will be measured on quantifiable ESG metrics, carbon reduction, net zero carbon emission commitments, diversity and inclusion measurements, customer satisfaction metrics, employee and safety measures that benefit all stakeholders. And you will have to be able to do that It's not that we stop working on these various things. I use the comment that as a mining lawyer, that we make the issues that we are the future. You can't have computers, you can't have electric cars, you can't have wind turbines, you can't have solar panels, phones, computers without the Earth's minerals. But it has to be done in a sustainable way that knows that you have created a better, broad space for the people that you work with, in the community in which you work, and how you've developed that. And it is critical for ESG if you're going to survive as a company going forward. Thank you, Stephen.
Oh, you're very welcome, Linda. That was excellent. I just have a very quick question for Jennifer King. Just in terms of the interconnectedness of E, S, and G, I wouldn't want to leave everyone this afternoon with the impression that these are silos. And Jennifer, for example, the connection between E and S, the connection between climate change and health. What do you think?
That was a soft lob, actually, Stephen. I've been thinking a lot about that over the past few years. And in fact, since I started, before I went into law school. And I think for environmental lawyers across Canada, we've been thinking about ESG for decades. My whole career, we've been thinking about it. And the reason why the environment and environmental impacts are important have long been connected with human health and haven't been limited to just what happens in a remote area. And specifically before the Supreme Court, my client, the Canadian Public Health Association, argued that that climate change is a public health crisis. It is in fact the most significant and most grave public health crisis of our lifetimes. So absolutely, the interconnection and the between E and S it's always been there, and we're really recognizing it now with COVID-19.
Thank you very much, Jennifer. Let's see if we can answer a couple quick questions from our audience. The first question is, I'm seeing ESG disclosure requirements with respect to public companies in Canada. What are your thoughts on how ESG may impact private corporations? Will there be any legislation that pose disclosure obligations on these private companies? So let me answer that really quickly. There is a bill before the Canadian Senate, Bill S216, which will be called the Modern Slavery Act. The Canadian Modern Slavery legislation will require companies, private companies over a certain threshold of revenue, assets, and employees, as well as public companies, to disclose annually the steps that they've taken to prevent or reduce the risk that there's forced labor or child labor in the production of goods that they are producing or importing. So that's an example of legislation that's currently at past second reading in the Senate. It's now being studied by the Senate Standing Committee on Banking, Trade and Commerce. That's an example of legislation that would impact private companies as well as public companies. Another question we can deal with is about, here's one about on the environmental side. Are there additional environmental regulations specific to Nunavut that are layered over existing federal ones? Jennifer?
Absolutely. So thank you. And I can't remember now who asked that question. I think it was Carla Beecher. Thank you for that question. Yes. So in Nunavut as a territory, Nunavut as a territory entered into the Nunavut Agreement in the 1990s. And there's a number of requirements under that agreement itself, whereby the Inuit in Nunavut exchanged their rights, their Indigenous rights, for this very specified agreement. And under that agreement, a number of pieces of legislation are required, and there are a number of bodies, including the Nunavut Impact Review Board, which I discussed earlier, which carries out the impact assessment in Nunavut. So unless there is transboundary effects to a certain extent where the federal impact assessment will take over, the impact assessment in Nunavut is run by these co-management bodies, which are very interesting regulatory bodies with very diverse representation. So the answer is yes, there is Nunavut regulation.
Thank you very much, Jennifer. We have time for one more question, and that is curious about the impact of legalized discrimination against religious minorities, Quebec Bills 21, and potential impacts of that on sectors outside the law's area of application. Should we expect to see anti-discrimination protections in the private sector rolled back, and how can we work against that trend? Nina, do you think you have some thoughts on that?
Absolutely. I do not actually see Quebec's Bill 21 causing a legislative reversal against the strong protections against discrimination. What I worry about is the cultural signal that was sent by Bill 21. And as we know, when we talk about social license is created by a number of factors, and legislation and law is one of them. And the signal that Quebec's Bill 21 sent was that certain people defined by their religion, and let's be blunt, it was largely an anti-Muslim piece of legislation, are the other. So while I don't expect to see legislative rollbacks or even case law rollbacks, I sincerely worry about the impact on the ground when the average person says, well, they are the other, and therefore I'm entitled to behave badly with respect to them. So I do worry about that, and I have kept a close eye on it. There's a number of groups that are proposing to take further legal challenges if they see any reversal in that area. So stay tuned for that saga.
Thank you very much, Nina. And thank you, Jennifer. Thank you, Linda, for your insights and perspectives this afternoon. And thanks to all of you who joined us this afternoon. We appreciate your interest, and hope that you have a great day. Thank you.